Imagine a will, not on paper, but etched onto a tractor fender. A testament to a life lived on the land, carved into the very machinery that sustained it. This unusual scenario played out in the 1975 case of George Cecil Harris, a farmer whose final wishes were as unique as his life. Harris, facing his mortality, used a hammer and a nail to carve his final testament onto his tractor. Each stroke of the nail was a deliberate act, a message to those he would leave behind. This unconventional act raises a fundamental question about the nature of legal documents. Can a will, crafted in such an unorthodox manner, truly stand the test of law? What makes a will valid in the eyes of the court? The answer, as we will explore, lies in understanding the intricacies of holographic wills, which are handwritten and often created in moments of urgency. This case highlights the enduring human desire to control the fate of their possessions after death, a desire that transcends conventional methods. It underscores the importance of understanding the legal requirements surrounding wills, no matter how unconventional they may seem. Knowledge is power in ensuring one's final wishes are honored. In the world of estate planning, clarity and adherence to legal standards are paramount. Every detail matters. The line between a valid will and a rejected document can be surprisingly thin, and the consequences of that distinction can be profound. Holographic wills, named for the ancient Greek practice of writing entirely by hand, represent a unique category in estate law. These documents, penned entirely in the testator's own hand, carry legal weight in certain jurisdictions. The key requirement is that the entire document, including the signature, must be handwritten by the testator. This distinguishes them from typed wills that are merely signed. The acceptance of holographic wills varies widely. Some states fully recognize them, while others impose additional conditions. Some states require witnesses to validate the handwriting. Others may insist on specific dating conventions. The lack of uniformity across state lines creates a complex legal landscape. This complexity underscores the need to consult with an estate planning attorney to ensure your wishes are carried out according to the laws governing your state. The year 2018 brought the passing of Aretha Franklin, the Queen of Soul. Her death, while a profound loss, also unearthed a legal quandary. Franklin, it turned out, had multiple wills, some handwritten, discovered in various locations within her home. This situation, far from unusual, exemplifies the legal battles that can arise from unclear estate planning. The existence of multiple wills, particularly when they contain conflicting provisions, can lead to protracted legal disputes among potential beneficiaries. Courts are often left with the difficult task of deciphering the testator's true intent. This task becomes even more challenging when dealing with handwritten documents, where handwriting analysis and the dating of the documents become critical factors. The digital revolution has ushered in a new era, not just in communication and commerce, but also in estate planning. The question of whether a will can exist solely in the digital realm is one that courts are increasingly grappling with. Can a document stored on a personal computer, a smartphone, or in the cloud be considered a valid expression of a person's final wishes? The answer remains a point of contention. While some legal experts believe that electronic wills represent a natural progression, others caution against their use. The lack of a tangible, physical document raises concerns about authenticity, potential for tampering, and the possibility of unauthorized access. Moreover, the ephemeral nature of digital data adds another layer of complexity. Can a file easily deleted or modified carry the same weight as a traditional ink-on-paper will? Section 5. The Dwayne Horton case. Can a cell phone will hold up in court? In 2017, the state of Michigan found itself at the forefront of this debate in the case of Dwayne Horton Jr. Horton, a soldier deployed overseas, used his cell phone to draft what he considered to be his last will and testament. He sent this digital document to family members, believing it would serve as his final wishes. Tragically, Horton was killed in a car accident, leaving behind this electronic testament and a host of legal questions. The court ultimately ruled that Horton's cell phone will was not a valid legal document, citing the lack of formalities required by law. This decision, while specific to the circumstances of the case, highlights the challenges of using electronic devices for estate planning. The lack of clear legal frameworks governing electronic wills, coupled with concerns about authenticity and the potential for fraud, makes their use a risky proposition. As technology continues to evolve, the legal system must adapt to address these emerging issues, ensuring that digital documents can be both secure and legally binding. Section 6. Intent, the heart of a valid will. At the core of any will, whether etched onto a tractor fender, handwritten on a napkin, or typed on a computer, lies the testator's intent. This intent is the guiding principle that courts look for when determining the validity of a will. The law seeks to honor the wishes of the deceased, ensuring that their final desires are respected and carried out as they intended. Courts, when faced with questions of validity, strive to determine the true intent behind the document in question. They meticulously examine the circumstances under which the will was created. Was it created with the clear and unambiguous intention of dictating the distribution of the testator's assets? This is a crucial question that must be answered. Several factors contribute to establishing intent. These factors help paint a clearer picture of the testator's true wishes. The clarity of the language used, which can either simplify or complicate the interpretation of the will, the presence of witnesses, where required, who can attest to the authenticity and voluntariness of the will, and the overall coherence of the document are all taken into consideration. These elements collectively help in validating the will. In cases where intent is unclear, or where multiple potentially contradictory documents exist, courts often rely on extrinsic evidence. This helps in resolving ambiguities. This evidence can include testimony from family members, friends, and legal professionals who may have interacted with the deceased regarding their estate plans. Such testimonies can provide invaluable insights into the testator's true intentions. Section 7. Navigating the legal landscape of wills in Michigan. Michigan law, like that of many states, recognizes the validity of holographic wills. However, specific requirements must be met for such a will to be deemed legally binding. The entirety of the will, including the signature, must be in the testator's handwriting. This strict requirement underscores the importance of careful drafting and meticulous attention to detail. In addition to the handwriting requirement, Michigan law mandates that holographic wills be dated. The date serves as a crucial piece of information, especially when multiple wills exist. It helps establish the timeline of the testator's wishes and can be instrumental in resolving any discrepancies between documents. Failure to properly date a holographic will can render it invalid, potentially derailing the testator's final wishes. Section 8. Avoiding pitfalls, common mistakes, and how to prevent them. One of the most common mistakes in estate planning is the assumption that simple means easy. Many individuals attempt to draft their own wills, relying on online templates or generic forms. This approach, while seemingly convenient, is fraught with risks. Estate planning is not a one-size-fits-all endeavor. Each individual's circumstances are unique, requiring personalized attention. Another common pitfall is the failure to adequately consider potential life changes. Marriages, divorces, the birth of children or grandchildren, and significant changes in financial circumstances can all impact the distribution of assets. It's crucial to review and update your will periodically to reflect these life events. Section 9. Seeking expert guidance. Why you need a legal compass. Navigating the complexities of estate planning, especially in a state like Michigan with its specific requirements for holographic and electronic wills, demands the expertise of a qualified attorney. An experienced estate planning attorney can provide invaluable guidance, ensuring that your will is legally sound and accurately reflects your wishes. An attorney can help you understand the nuances of Michigan law. They can guide you in choosing the most appropriate type of will for your circumstances. They can also assist in drafting a will that clearly and unambiguously expresses your intentions, minimizing the potential for disputes among your heirs. Section 10. Securing your legacy, a final word. Estate planning may not be the most pleasant of tasks, but it is undoubtedly one of the most important. Your will, whether etched in steel, penned by hand, or typed on a keyboard, represents your final wishes. It is a legacy you leave behind, impacting the lives of your loved ones long after you are gone. By understanding the complexities of holographic and electronic wills, by heeding the lessons learned from cases like those of George Harris, Aretha Franklin, and Dwayne Horton, and by seeking the guidance of a legal professional, you can ensure that your final wishes are carried out with clarity, compassion, and in accordance with the law.